All right. It looks like the number of people logging into the room has slowed to a trickle, so that's good. My name is Andy Yost with the Capacity Building Center for Courts. I'd like to welcome everybody that's joined us today to hear about the Children's Bureau's Information Memorandum on Quality Legal Representation. I'm not going to say a lot about the actual content here. We have 4 experts and David Kelly from the Children's Bureau who are going to speak to that. What I'd like to do, though, is get you oriented a little bit to the room that you're in right now and just explain some things from a technology perspective that you're going to experience. So what you're in right now is a space called an Adobe Connect room. It's some webinar software that we use at the Center for Courts. And let me just describe for you what you can see. In the center of your screen, you can see a slide deck. We're going to use those slides for 2 reasons. One is sort of benchmarks or signposts for where we're headed. And also there's some content that we're going to deliver through that slide deck as well. In the lower left-hand corner of your screen, you'll see a little square that says CB and CBCC Virtual Event Agenda. And that's exactly what it is. It's an agenda. You have our stated purpose for this webinar that'll last about 54 more minutes. The purpose is to announce the information memorandum and provide 4 experts' advice answering the question, what out of the model you studied is most helpful to us as a national audience in carrying out the information memorandum's call to action? We are about 7 minutes into a 9-minute welcome. Then we have a 5-minute announcement from David Kelly and the Children's Bureau. That'll be followed by 4 9-minute presentations that answer our question that we've articulated in our purpose. We have a 5-minute session on the using practice standards to promote quality representation in your jurisdiction. And then we have a brief 5-minute closing at the end. So that's sort of what we have lined up for today. In the middle of your screen, there's a chat box or a chat pod, we call it. Feel free to ask questions throughout the conversation in that chat pod if our presenters are able to read the chat pod, because it usually ticks away pretty fast. They may get a chance to answer your questions, but also have questions between each other. So if you have a brilliant idea or something you'd like help on or advice on, feel free to write that into the chat. Know that the chat transcript is saved, which is valuable for us because if there are questions that we don't answer during this meetup, we can always follow up and try to answer those questions as well. And if they're good ideas that are shared with the group, we can capture them in the transcript. If you'd like to have a private chat with someone, you're invited to do that as well. All you need to do is hover your cursor over their name. In the upper right-hand corner of your screen, you'll see a list of attendees. If you just hover over someone's name, a little box will open up and it'll say Start Private Chat. Just click that and you'll have a little private chat available to you in the bottom of your screen. In the bottom right-hand corner of your screen, there's a gray square that says Files. That's a number of files that we've uploaded, all of which are relevant to the content that the presenters are going to deliver today. And the information memorandum and the appendix are also in that list of files. So to download one of those files, all you have to do is click on a file. The button Download Files will illuminate. Click that button and it'll download to your computer. Or there's a little drop box in the corner with a sort of 4 lines and an arrow. If you click that, you'll have the option to download all of the files. Those files will be available to you throughout this meetup. One last thing, and then I'm going to ask David Kelly to say a few words to get us started. I'm going to move the screen around during this hour-long meetup. That's all planned. Your computer isn't going to catch on fire. Nothing's crashing. So just hang tight and enjoy the ride. We know what we're doing, or at least we're very good at looking that way, and we've been planning this for a while. So know that that's all intended in the design of this meetup. So with that, I'm going to move us to the first room, and I'm going to invite David Kelly from the Children's Bureau to say a couple words about the information memorandum and its purpose. So David, yep, I see that you have your computer running. I'll be quiet, and the microphone is yours. Thanks.
Thank you, Andy. Thank you, Andy, and good afternoon, everyone. Again, I'm David Kelly, and on behalf of the Children's Bureau, I'd like to extend a hearty thank you for making the time to join us this afternoon. If you've yet to read the information memorandum, as Andy pointed out, it's available down in the right-hand corner of your screen. And we encourage everyone to take a look. and not just to take a look, but also to discuss it with colleagues, both within your own agency and with the courts or any other partners that you may have. It's a little bit longer than our IAMs tend to be, but that's a direct reflection of the outstanding work that has happened in this area. The central message of the IAM is very straightforward, and that's that high-quality representation for all parties in all stages of child welfare proceedings is absolutely critical to a well-functioning child welfare system. This is true as a basic matter of justice, and is also supported by a growing body of evidence. There's evidence that now shows or links high-quality legal representation to increases in party perceptions of fairness, increases in party engagement, increases in case planning, attendance at court, more personally tailored and specific case plans and services, increases in visitation time and parenting time, expedited permanency, and cost savings to state government. In the perspective of the Children's Bureau, high-quality legal representation advances our core work and contributes to advancing safety, permanency, and well-being. If you're committed to a fair, transparent, and effective system, there's a corresponding commitment to legal representation for all parties. Now, the purpose of the IAM was to pull together best practice, ideas, and models, is to draw upon the most important research that's been conducted in the field and present it all in one place. Not intended to be overwhelming. It's intended to demonstrate that every jurisdiction could do something to improve the quality of legal representation in their state, in their county, in their municipality. So today's event is intended as the first in a series that will continue at least for the next year, where we create opportunities to delve deeper into best practices, strategies, and create opportunities to discuss just how important this topic is. Today we're going to hear from just a few individuals whose work is highlighted in the Information Memorandum. And I will not stay on screen any longer, so we can move on to hear the contributions from the experts. Thank you, Andy.
Great. Thanks, David. I'm going to move us now to a new space. So, again, you'll see your screen move around a bit. And I'm going to invite Vivek Sankaran from the University of Michigan to talk about the work that they've done. So, Vivek, you obviously can hear me since you've turned your webcam on, and we can see you as well. So the microphone is all yours.
Sounds good. Well, thanks so much, Andy, for having me and making me a part of this. I wanted to spend my limited time with you all, first applauding the federal government for issuing this information memorandum. For many of us who have been doing child welfare work, it is a long overdue sort of hearing about the importance of legal representation. But one of my first reactions when I saw the memorandum is a sort of a feeling of being overwhelmed, right? So where do you start? There's so many different aspects of legal representation. And I wanted to talk just for a minute about our experiences at the Detroit Center for Family Advocacy, which really, in my mind, highlighted two important issues to think about. One is the early appointment of counsel, and the other is ensuring that legal counsel also work on collateral legal issues. So what do I mean by that? Our model in Detroit, which is a center that started in 2009, was that we would get referrals from child welfare agencies even before a petition was filed. And then our legal team worked with the Child Protective Agency on behalf of parents trying to resolve the case so that a petition would not need to be filed. And central to our model was handling collateral legal issues. And so both we got involved before a petition was filed and we worked on collateral legal issues such as custody issues, landlord-tenant, domestic violence. And what we found in so many of our cases is that appointing counsel for parents early on in a proceeding and allowing parents counsel, really the breadth of trying to resolve the issues that confronted the family, really played an important role in making the child welfare case go away. And so as part of my work at the University of Michigan Law School, I also do systems work in a number of different states, looking at how systems are doing as it relates to parent representation. And one of the things that I have seen throughout the country is many jurisdictions don't adequately appoint counsel for parents and children early on in the process. At the TPR stage, as a nation, we do pretty well. That in almost every jurisdiction, but counsel is guaranteed for parents. But where we still fail in so many situations is first appointing counsel, even at that first preliminary hearing in a child protective case, and then allowing counsel to pursue some of these collateral legal issues, like the ones that we handled at our Detroit center. And what I've seen across the country is that child welfare cases then slow down because some of these legal issues linger, keeping cases unnecessarily open while kids remain in foster care and we waste public funds as well. And so in many ways, we have sort of opted for systems that not only produce bad outcomes for families, but also cost systems quite a bit of money. And so I really wanted to highlight both early appointment and collateral legal issues as things that I'm hoping that states, based on this memorandum and our experiences in Detroit, will really look towards addressing as they move forward. In terms of sort of my thoughts on next steps as to how states can build on the memorandum, I think it's crucial, whether it's through the Court Improvement Project or the Child Welfare Agency or other entities within state systems, that each state take a period of reflection to figure out how they fare in terms of some of the barometers of a good functioning system of representation. What do I mean by that? How do they fare on when counsel is appointed? How do they fare in terms of compensation for counsel? How do they fare in terms of access to resources for parents or children's counsel? And I think the first step in any of this process is really to do that introspection. In Michigan, for example, what we're doing right now is using some CIP funds to hire somebody on a short-term basis to collect data for us. We think of systems of representation as statewide systems, but in many places like the state of Michigan, it really is a county-specific system where every county seems to be doing somewhat different practices, and it's very difficult to assess what is going on in our state. So, for example, if someone were to ask me, how is counsel appointed or compensated in Kent County, Michigan, it would take some work to figure out how that happens. It'd be phone calls. There's no centralized repository to collect that information. And so I would really encourage states, just as a starting point to build off this memorandum, to do that assessment, to figure out where you are at and also what your priorities are. Because this is a huge problem that's not going to be solved overnight. But what I would encourage states to do is prioritize. Are there structural issues that need statutory changes or court rule changes? So, for example, in Michigan, we don't have a statute that allows counsel to pursue collateral legal issues. And so that sort of suggests to me a statutory change that may need to take place. Is it a question of funding? Right? So is it a question of going to your legislature and collecting data, which, as David had stated, there's a lot of data now out there, much of it which is contained in this information memorandum, talking about the economics of reform and why it makes sense. We can now take that to the legislature and to the county commissioners. Are there pilot projects on a short-term basis that we can implement? So, for example, in Genesee County, Michigan, through funds from both our Court Improvement Project and Casey Family Program, we were able to design an intervention where a social worker was working with a group of parents' attorneys And then with any good pilot project, they collected data from that project and evaluated it, and now can take those good results to those legislatures. And so what I would really encourage states to do is do the assessment, figure out where the barriers are, and then prioritize. Figure out what you want to address, have a standing committee within an existing structure of some sort to address it. If you create a pilot project, collect data and evaluate it, and then go to those in the foundation world. In our Detroit Center, we initially got funded primarily through private foundations who had typically funded non-legal child welfare interventions. But when we proposed this project to them, they saw the link between the legal system and outcomes for children. And I think where this information memorandum is so crucial is that we don't need to do the work anymore of selling this to third parties, because much of the information that we've all been collecting for years on our own has now been integrated into one comprehensive document. And so I think this is a great first start for the information memorandum, but I'm really hopeful that, like many, many reports that have been generated in our field, that this doesn't just stay a report, and that now as a community we can act on this, assess, identify, figure out what you want to prioritize and implement. In terms of the top collateral issues that I see that I wish that parents and children's attorneys could address, first, custody issues, particularly for non-offending parents. This is a big issue in Michigan. We have many, many non-offending parents who have kids placed with them in the child welfare system, and yet their lawyers aren't statutorily authorized, and they don't get paid for handling the custody cases, which then delays the closure of a child welfare case for quite a bit of time. We have guardianship issues that arise when grandparents are seeking guardianship. We have domestic violence issues, the seeking of a restraining or a protective order for a victim of domestic violence. We have landlord-tenant issues dealing with housing that may be the root cause of the safety issue. So those are just a few of the collateral issues that I encounter. So I see my time is quickly up. If you have questions, feel free to put it in the chat room, and I look forward to working with you all as we implement this information memorandum.
Great. Thank you very much, Vivek. We really appreciate your insight. And thanks for fielding that question. Again, just to echo his comment, if you'd like to continue a conversation with him in the chat pod, please go ahead and do so. He's going to be on the call for the remaining time as well. We're going to move on now to Addie Smith, who's going to speak to us a bit about her experience. So, Vivek, we'll have you turn your webcam off, and then Addie, if you want to go ahead and hit start webcam on your own. Thanks, Vivek. And in the meantime, people will respond. We have 3 polls up that we'd like you to respond to. Addie, we see you, and your webcam's obviously working, so I'll be quiet, and you're all set to go.
Great. Well, this screen looks very busy, which I guess speaks to my style and my presentation style. But if people could fill out the surveys, I'm really interested to see what people know and don't know about their system. I think what's going on the agency side stands in stark contrast to what's going on the parent and child representation side. So I should start by saying I am not myself an agency attorney. However, I ran a task force here in Oregon looking at our representation system. And one of the things we discovered over the course of our year of what Vivek was just discussing, reflecting, taking inventory, looking for data, et cetera, is that there's actually very little data out there about state or government representation in child welfare. It appears that for quite a long time, people took for granted that agency representation was well-funded and stable, and since there was no need for kind of an advocacy effort, there hasn't been a lot of data-driven research. There hasn't been a lot of practice that has been determined to be evidence-based. So we're a little bit in a vacuum when it comes to state and agency representation, but I do want to take some time to share what's out there and to share a little bit about our process here in Oregon, because since it was that inventory reflection and then recommendation process, it's really translatable to other states. So I think what we'll start with as we watch all of these polls roll in is the first piece, a big debate. So there is and it is very contentious because I've had conversations across the country with individuals, debate about what the best model is. And so it's important to address that, and then I think we're going to move on to what's even more important than the model. So the agency model, the prosecutorial model, and the infamous hybrid model. What are these? I see people filling out the survey that asks just this question: who do the government attorneys represent? I sent a survey out about a year and a half to all of the JSIP coordinators across the country, as well as to all the child welfare program directors across the country, to each of those listservs saying, hey, we're doing this big process. Can you tell me what kind of representation you would have? And I think the most fascinating thing about the survey to me was that a lot of people couldn't quite pinpoint, oh gosh, what kind of representation do we have? Who is the entity that's represented? So you can see kind of the data I provided, which is the preliminary numbers from 31 states that I was able to speak with a year and a half ago. But what we see is that the majority of states have an agency model. An agency model is what it sounds like, right? The attorney actually represents the agency, so DHS, DPHS, DPPHS, OCS, every state has its own acronym. But the attorney is much like an in-house counsel, and sometimes they're literally in-house. Sometimes they're attorneys general who work with the agency, but the client is clearly defined as the agency itself. Now, one of the concerns that comes up about this model is that often individual caseworkers think that the attorney represents them, and of course it is more broad than that. So that's the agency model, and we see that in the majority of places. There are, however, a wide range of states that use what's called a prosecutorial model. So a prosecutorial model is also exactly what it sounds like. The client is actually the state, and as our Supreme Court here has labeled it, the state qua state. So it is that entity that's often and most frequently understood as the entity in a criminal proceeding. And in that situation, we see some real benefits because, of course, you're close to your community, you're answering to your community standards are driving your practice. But there can be some real disconnects. Because what happens in that situation is that the district attorney or prosecutor, however they're variously named, often goes into court and disagrees with the agency and the agency's decision and is not bound in any way to work with the agency towards a resolution around what the decision for that kid and family should be. And I imagine that those of you on the phone can think of a wide range of other concerns that sometimes arise under that model. The third model that we see around the country that I think is important to understand because it's what we're dealing with here in Oregon and poses some really particular challenges is that the hybrid is where here in Oregon we have our DAs or our prosecutors represent up through what we call jurisdiction, which is adjudication in many states. And then we switch over and the attorney generals take over and the agency is represented for the remainder of the proceeding. And the of concerns or problems or delays that causes are hard to count on one hand. So these are some things that we've discovered. Now, what's really important, and let's see if I know how to move to the next slide. Andy, maybe you can help me get to the next slide. Oh, no, one more back. Okay, perfect. So what we ended up doing in Oregon and what I think is worth taking note of is that when you spend a lot of time debating the prosecutorial model versus the agency model, what's really gets lost in translation is what the characteristics of a good system are. So as a task force, we spent literally months poring over the limited literature that is out there, and I've included both our report from our task force as well as the ABA model standards for agency representation, looking at what are the characteristics of a good system. So if we step away from this debate, right, what does it mean to represent the agency well or to represent the government well? And what we really determined is that more important than the model are these characteristics that you can see. And I just wanted to really quickly walk you through them and then move on to the closing point. Availability. You need to have attorneys who are available to social workers without any limitations. Consistency. When we talk about consistency, we want to see if you are in any given county or any given district, your family is going to be treated the same way. Cost effective or cost efficient. There are states that have all kinds of different models, but if cost is prohibitive, that's going to stand in the way of a good system. Comprehensiveness. This harkens a little bit to what Vivek was saying when working with parents and kids. You want your state's attorneys to be able to work on the appropriate collateral issues in state. For example, SIJS cases. For example, those attorneys might be helping when there's an issue around a foster care and a desire to have a waiver. Things that certain systems lend themselves better to than others. Continuity. You want the same attorney, if at all possible, with the same perspective, working the whole way through the case. Switching over in the middle doesn't provide good outcomes for kids and families. Local community connection. It's really important, and I know everyone faces this, whatever their capital is, whether it's Olympia, Salem, Sacramento, Columbus. You don't want, the edicts coming from afar about what needs to be done. There needs to be some flexibility to answer to the community. Manageable caseloads. I know we hear about this a lot on the parent and child side, but we see the problem also on the state side, and it prevents good practice. And then objectivity. And so what we came to think about here a lot in Oregon was the fact that you want to have a backstop. You want to have the ability to say, ultimately, the safety of the child is important and someone is looking out for that. So those are the attributes we talked about. And if we flip to the last slide, what we really realized was the most important thing in helping for good outcomes for kids, for efficient practice, and for effective practice was that there are systems in place for attorney-caseworker relationships. So there's conflict systems. If there's a huge disagreement between the attorney and the caseworker, there's a formal way to work that way up the chain of command. There are policies around communication. There are regular staffings, and there's a built-in level of trust that goes both ways. So the attorney's trusting the caseworker's social work skills, and the social worker is trusting the attorney's lawyer skills. And that's what actually leads to that fine balance of doing what's legal and appropriate, but also best for kids and families. So I'm also going to be hanging out for the rest of the webinar and happy to answer any questions, but that was a quick 10 minutes about what to be thinking about as you do an inventory and reflect on how your state is represented in the child welfare system. Thanks.
Great. Thanks so much, Addie. That was really great. And just to echo her comment, feel free to have a continuing conversation with her in the chat box if you'd like. Addie, I'm going to go ahead and close out your webcam now. And Michelle, if you want to start your webcam and get your technology up and running there, we'll hand the mic over to you. So you'll just need to hit start my webcam and then hit start sharing.
Okie doke.
Okay, great. We can see you. Thanks.
Okay. So thank you for including the Center for Family Representation and me in this important discussion. We appreciate being a part of it. I just want to point out that Andrew and I had some last minute back and forth about the PowerPoint, which is why you're starting with this super boring slide. The whole PowerPoint is in the files, right, Andrew? If you scroll down to the very end. I wanted to say a little bit about the Center for Family Representation. For the last 10 years, we have functioned like the public defender in Queens County and in New York County in New York City, which means we represent about 2,000 parents a year in dependency proceedings, as well as now more collateral legal proceedings, but all the way through termination or any other permanency, custody, whatever. Similar to some of the things that were highlighted in the federal memo, we practice in teams of attorneys and social workers, and we also have on our staff parents who have been through the child welfare system themselves. They have had their children removed. They have been prosecuted. They've successfully reunified with their children. We call them parent advocates. They have different names in different places. So that's how our teams function. In terms of takeaways and some of the things that were both in the memo as well as things that I think jurisdictions can focus on, those of you who know us at CFR know that it's not really going to be a surprise that we're going to urge practitioners to focus on 4 areas when children go into foster care. And I don't mean we focus on these to the detriment of a really rigorous investigation or mounting a really strong defense, but we have found that when we focus on these areas, our clients' children do not enter care as often as they used to. They continue to come home more quickly than they do throughout the rest of New York State. And very importantly, they re-enter care less frequently than is true throughout the state. And I'm going to focus a little bit on visiting because we only have 9 minutes, and I sometimes spend 90 minutes talking about this. And I do think that in every jurisdiction there's the ability to focus on visiting and high-quality visiting arrangements for parents and children when children are separated. One of the things that I thought was poignant and moving about the memo was it talked about how important it is for parents to feel as though they have a voice in these proceedings. And visiting is a place where they not only get to say something about how they would like visits to go, but they get to remain the parent. When they are visiting with their children is when they're reminded of what matters most to them. And what we see is that the parents tend to get more engaged, not just in the child welfare process, but also in the court process. They feel more progress. They feel more confidence. They're maintaining contact with their children. And I think very important, it helps the court, the prosecuting agency, whatever your model is, as well as the child's attorney begin to see the parent differently too. So the parent who has visits where she gets to read bedtime stories is no longer just the parent accused of addiction. And the parent who says in court, I'd like to go to my child's doctor's appointment, is suddenly more than just the parent who is accused of having a bipolar disorder that's untreated. So the whole system begins to see the parent differently, and we find that really focusing on visiting rigorously and with everything you've got in terms of creativity as well as law really sets the case on a path towards reunification. As you see in the slide, what we mean by high-quality visits is that visits should happen often. They should be as long as they can, with as little supervision as is absolutely necessary, and organized around activities that mimic family life. And we have in New York and urge everybody in whatever jurisdiction you're in to explore the visit host practice, which was very new to New York back in 2007 and 2008. But through a lot of very concerted work on the part of our staff, as well as advocates both for children and parents around the city and the help of the child welfare system, visit hosts became a practice that is now fairly common and not terribly controversial. And that's just a situation where the family, usually older youth, a parent, or a community support, identifies someone who can be with the family not in lieu of a caseworker, but in addition to a caseworker, so that a family can do things together that they used to do, that they have good memories of, whether it's going to church, it's going to a ball game, it's going school shopping, and it really enables child welfare systems to offer families more visits than they otherwise might be able to, because as most of us know, even when the average caseworker would like to give a family more visits, they're usually limited by resources. The other thing I urge every state to do, which is not really new, but just to dust off everything you probably have in terms of statutes, regulations, and administrative directives or guidelines on high-quality visiting. CFR has been now to many jurisdictions and has helped practitioners in many jurisdictions, and no matter where we go, whether it is a West Coast state, an East Coast state, a Southern state, as it turns out, people have already written a great deal about visitation, about the fact that visitation is the single best predictor for safe reunification. And usually, as an advocate, there are things that you can draw on. So you don't just have to make an argument that pulls on the heartstrings. You can actually make a legal argument about visits and about high-quality visits. And again, although it is no longer one of your slides, just to give you an example, in the state of North Carolina, there is a statute that makes clear that reasonable efforts include a visiting plan. There is a regulation that says that a child welfare agency has to encourage the participation of other relatives in a visiting plan. And there is a DSS Family Services Manual that you can just find on their website, and I'd urge you to go to all your DSS websites as well as your state website. But there's a manual that makes very, very clear and says that the single most powerful relationship upon which to build is the attachment between the child and the parent. And attachment is often the motivation for a parent to engage in needed services. It also goes on to say that visits should occur frequently in positive natural settings. So if you're an advocate and you're going into court, or if you work for the court and the judge you work for says, do I have the legal authority to order a visit host to be explored or to order more visits, it's usually right there in your jurisdiction. In the PowerPoint, we've given a few more tips about how you can just get started. Vivek talked about feeling overwhelmed. A lot of our tips are very easy to do. They don't take a lot of time. They don't cost a lot of money. They just require changing the way things are framed and perhaps doing a little research, and then always important, just getting together with like-minded people to try to strategize about creative solutions. So I think I'm still within my time, but I'm also happy to answer questions.
Great. Thanks, Michelle. And for those of you that can't see it, which is probably most of you, we have a little timer running. I just want to commend Michelle for reserving about 50 seconds on her timer, which is rare. I'm an attorney myself, and it's rare for attorneys to yield 50 generous seconds. So thank you, Michelle. And let me just echo her point as well. If you have questions for Michelle, feel free to type them into the chat box. She's been generous enough with her time to stick around to the end of the hour. So just type Michelle and whatever question you might have, and she'll jump in there and answer it as well. So thanks again, Michelle. I'm going to move us now to our second to last speaker for the day, who is Don Duquette. Don, I've moved us into your room. Can you go ahead and hit the start my webcam button and then start sharing?
How's this?
Great. That's perfect. We can see you, and the microphone is all yours.
All right. Thank you. Thank you, Andy. And it's a pleasure and a privilege to be part of this great conference. And I'm delighted to see so many people engaged in this important conversation. Thanks to the Children's Bureau and especially David for leadership on this. In my 9 minutes, I want to try to summarize the Quality Improvement Center on child representation that just completed last year. This is a 7-year, $6 million project. I want to address the question that ties into the Information Memorandum, which is, what did we learn, and how can what we learn help you in trying to improve child representation in your state? All that I'm going to say today can be retrieved easily. Andy will tell you later that this session is recorded, and you can review that again. Our QIC website is on your screen right now, and that contains all of the 6 core skills training that I'm going to summarize in a minute, the empirical data, how we did the study, and it includes our policy recommendations. And maybe the best source for information about the National Quality Improvement Center is a book that's just out, Children's Justice, How to Improve Legal Representation of Children and the Child Welfare System. It tells the story, the whole story, including a detailed presentation of the training that I'm going to summarize, an analysis of our empirical data, and an analysis of the data. The book was subsidized to keep the price low, and our publisher is ABA Publications. You can get the link at ABA, or you can get it from our website. CIP directors, of which there are many online here, should have received their complimentary copy of the book by now. But here's the ultimate takeaway from all of this, which is we identified a model of child representation that seems to reflect a consensus in the nation. We field tested that model. The lawyers liked the 6 core skills model. They practiced in accordance with it. And when they did, they got better results for their child clients. The QIC model training and research data are all available in our book and on our website. And there's a separate study that demonstrates the value of multidisciplinary representation of children, something that's fairly popular, but this provides one of the first random assignment experimental designs in support of that, and it showed terrific results about how that interdisciplinary work improved outcomes for children. So what we found, we studied 4,000 children, 240 lawyers in 2 states, Georgia and Washington State, and the lawyers that trained in our model performed better than the control group. They saw their children more. They consulted more with caseworkers. They talked more with other lawyers. They talked more and consulted more with other players. They attempted more negotiations, and they moved their cases forward. The certain children spent less time in care. This is by statistically significant differences. Early appointment made a difference. That's where the outcomes were significantly different. Kids seemed to be in flux early in the case, and that's the time to give them, as well as their parents, I'd say, good representation. I want to summarize the 6 core skills, but first you're going to say, geez, Don, aren't you going to cite any cases or court rules or anything? The idea of these 6 core skills was to reflect the best practice model that we developed, all of which is available, as I said before, but also to open the lawyers' minds to dimensions of the case that they may not otherwise see, that law school education alone would not prepare them for. And once the lawyers used QIC principles to identify the goal, they used their traditional legal skills to marshal whatever legal authorities, strategies, and arguments that could achieve those goals. As we heard before, once a lawyer understands how important it is to do visitation between child and parent, the more aggressively the lawyer will pursue that. Our training assumed that the lawyers either knew or could get training in their state law and in the basics of trial practice. That was important to us. And our assumption was not misplaced. The lawyers were really quite sophisticated. The lawyers who did this had practiced for an average of 13 and a half years, most of whom practiced more than 5 years in child welfare, and many much longer than that. So they compared in longevity quite well to agency caseworkers. People who do training know that the decay rate is very high. People forget what they learn, even in the most effective training. So we needed to reinforce the model. We had quarterly small group pod meetings of the lawyers, regular contact with a coach to keep the 6 core skills fresh and to keep the concepts applied to their cases. From an adult learning perspective, a linear cookbook approach would be cumbersome, would be hard to internalize. We figured the lawyers would enjoy an interactive problem-solving approach to the training that respected their existing knowledge and skills, and that too was not misplaced. The lawyers were eager to learn new skills, and we were very pleased with that. Now, the 6 core skills themselves, to many of you on this line who are fairly sophisticated, you're going to say, well, of course, but lawyers actually reacted to this by saying it's a structured, disciplined, rigorous model, and we were pleased to hear that. Enter the child's world means what you think it probably means. Basics of child development, trauma-informed knowledge about the child, how to engage with the child, learn a child's needs, guide them, talk with them, counsel them, and advocate for their needs, accommodating their stated interests as much as possible. That was important to us. The second one, assessing child safety, we stole a lot from Jen Rennie. We wanted to protect the child without overreacting. Remove the danger, not the child. Kids stay in care too long very often, and we wanted to cue the lawyers to that particular risk. Why can't this child go home today is one of the questions we wanted lawyers to ask. Actively evaluate needs. We wanted lawyers to realize that this is part of their job, to evaluate the case. It's really akin to discovery. We wanted to facilitate an appropriate assessment. Advance Advanced case planning means a development of an appropriate case plan. That too is part of the lawyer role. Case theory helps drive the case because we want the lawyers to ask what's going on here and where is this case going. And advocating effectively means use problem solving and non-adversarial approaches as much as possible, and that's what they did. But you still got to litigate a case from time to time. I've got just a couple of takeaway points I'd like to give to some of these principal people, to CIP directors and staff. We addressed the paralysis of the best interest client directed divide. We're not as far apart as you might think. To agency welfare leaders, we lessen the adversarial tone whenever possible, and we advance state interests by keeping the children out of care. For trainers and educators, we want to say the entire training is outlined in the book and the materials are on our website. To lawmakers and those who advise them, we recommend that you adopt the 2011 ABA Model Act for legal representation. We need a structure for that. Echoing something other speakers have said, a statewide structure for lawyers who represent children as well as represent parents seems essential. Lawyers need that kind of framework, and it's going to help both the lawyers and the delivery of the services to the children and the youth. Thank you for letting me participate. Good luck to you all in achieving justice for children.
Great. Thanks so much, Don. Really appreciate your comments. Again, Don is going to remain with us. So if you have questions, feel free to ask them in the chat pod, and he'll respond to them accordingly. Our last speaker of the day before we close is Mimi Laver from the ABA. So, Mimi, if you just push the Start My Webcam button on your screen, and then click Start Sharing, you should show up on our screen. Excellent. Okay, we see you. I'll be quiet, and the microphone is yours.
Hi, everyone. Thank you, Andy, and thanks for allowing me to participate today. I'm just going to talk for a few minutes about how standards of practice can be a tool for improving representation and living up to what the IM is hoping all of us can do. So in your file section, you will see the national standards for agency attorneys, children's attorneys, and parents' attorneys. These are all the ABA standards. NACC also has standards for children, and there's also the Model Act standards that Don just mentioned. The goals of the national standards and of statewide standards is to promote quality representation and consistency all around your state and the country. Just because a parent or a child lives in one county, they should have the same excellent representation that they do in another county of your state and in another state of our country. At least half of the states in the country have passed standards for parents' attorneys or for children's attorneys. We don't have too many states that yet have their own agency attorneys, although they do exist. And I think it's a great practice for CIPs or other groups around the states to get together and figure out what is it that they want from their attorneys. How can they raise up the level of representation? Different states have used different models of incorporating the standards, some in regulations, some by case law, some in court rules, and some are just aspirational standards that help us guide what we should be doing. As you can see on this slide, I don't think standards are a magic bullet. They're not going to all of a sudden say, ooh, we now have excellent representation through our state. But it does guide the attorneys and the courts to figure out how they can lift up the representation. Just so you know what to expect when you open the standards, they have black letter standards that lay out what can I do, what are the actual standards for attorneys. There's actions and commentary to help guide how we can enact the standards, and in fact, there is great overlap in the themes of the standards of the three kinds of attorneys. So I just wanted in a few slides to show you some of the most important themes, and again to show you that there is overlap. So client participation and representation is particularly important for parents' attorneys, but also for children's attorneys and agency attorneys. And the standards for all three go on about how you can engage your clients as the attorneys. Preparation, again, goes throughout all three kinds of attorneys. The multidisciplinary model is one that Michelle and Vivek just talked about, how social workers, parent advocates, youth leaders can be part of the legal team, and we all believe that that's really the highest kind of representation, the best kind of representation that legal teams can offer for clients. Advocacy outside of the courtroom, for those of you that know me, know that that is probably one of my biggest mantras, and I think Michelle did a really great job of talking about the cornerstones and especially visitation. And throughout the standards of representation for all three kinds of attorneys, they describe how attorneys can act outside of the courtroom to further the goals of their clients. And you'll notice in all three standards that we lay out ideas for the court or for attorney managers, others that can support the attorneys. So the themes of the child attorney standards, again, really mirror what we've just talked about. They talk about the ethics of being an attorney for a child, and there's a lot of challenges there that are maybe a little bit different than for a parent. And finally, the themes of agency attorney standards. And one thing I would say for those of you that might want to take the agency attorney standards and implement them for your state, while the idea of strengthening families is a theme, I think it should be even greater than it was when we wrote those standards many years ago. And I just want to highlight for you a couple of states that have done an excellent job of taking the national standards and making them state-specific. For example, in Pennsylvania, their standards talk to both children's attorneys and parents' attorneys in one document, and they also have looked at caseload analysis and how it matches with the standards. Other states are specific for children's attorneys and parents' attorneys. Any which way that you think will fly politically in your state is a great way to go to design a tool like standards. If you need any help, happy to offer it.
Great. Thanks, Mimi. Really appreciate your comments there. And also, she'll be on for the next few minutes as well. So if you have questions, we welcome them in the chat box. We're now going to have just a couple brief closing comments from the Children's Bureau and David Kelly, and then everyone will be free to go. So, David, are you on the line?
I'm on the line, yes. So I'd like to wrap up again by thanking our presenters and all of you for making time to be with us today. As I mentioned, this is intended as the beginning of a sustained effort to highlight the importance of legal representation. And it's the perspective of the Children's Bureau that high-quality legal representation helps keep families safe, together, and strong. There was a lot of information presented today. We hope that it plants seeds for you to consider. We encourage you to have conversations in your jurisdiction to begin assessing what the state of representation is. So again, if you have not read the memorandum, we encourage you to do so. And we thank you all for all that you do for kids and families.